The easiest and least painful divorces are uncontested divorces. And those are divorces where the parties agree on everything. If you don't have kids, then you don't have to worry about the parenting time or the custody of the kids. All you have to worry about is the division of property and debt between the two of you. What usually happens is the husband and wife will enter into what we call in Tennessee a marital dissolution agreement. Some states call it a property settlement agreement. But it's an agreement between the parties, a contract stating how you're going to divide up the property and the debt of the marriage. It has to usually be signed, notarized by a notary public under oath, and then presented to the court. And the court will make sure that it's a fair and equitable settlement and that both parties understand that agreement and understand the terms of that agreement. And then the court will grant a divorce to one party or the other or declare the parties divorced. There's something I see in the law occasionally, and I call it a backdoor adoption. What usually happens is a mom will get pregnant with a child, usually from somebody that she really doesn't care about and doesn't want to raise her child. And she really doesn't want this person to have anything to do with her child. But while she's pregnant, she falls in love with somebody else. And when the baby's born, that somebody else signs what we call a voluntary acknowledgement of paternity, stating that he is the father of the child. The mom signs the same form, and that person becomes the legal father of that child. Now, he's not the biological father, but nobody's going to ask. And he raises the child as his own. Now, usually when I see these types of cases, I see it at the point where that father, that person that signed the voluntary acknowledgement, claims that they're really not the father. They're now being put on child support or something else, and they're now stating, well, wait, I'm really not the father. It's too late. Once a certain amount of time passes, that's it. You're the father of that child. This week I had 2 custody and visitation cases. In one of the cases, the parents, who were very well educated, entered into a parenting plan that literally spelled out every single detail of the parenting time that each parent had, of the decision-making that each parent had, of what happened if a parent was late to pick a child up. Just every single thing, detail-oriented, down to the minute little detail. Now, those parents are going to stick to that parenting plan. Had another case where the parents simply said the parents agreed to split custody equally between themselves based upon their ability, their time, their job, etc. Those parents are going to throw that parenting plan in a drawer and they're going to parent their child the way the child needs to be parented without regard to the little itty-bitty details. What a contrast. You know, one of the problems we're seeing a lot now as lawyers is the backlog that courts are experiencing because of COVID. Here's the problem. People are really getting upset that their cases aren't moving quickly. Their divorce cases, their child custody cases, whatever type of case they have. I heard a clerk on the phone, courtroom clerk the other day, talking to a litigant who was upset and was yelling and screaming about how their case has been sitting there for over 2 years and they can't get a court date. And that clerk basically told them, look, we're doing everything we possibly can. We've got a backlog like you wouldn't believe. Your case isn't any more important or less important than anybody else's case, and we're trying everything we can to move those cases through the system. Let me tell you, folks, you got to be patient with all this stuff. We all have to be. Things are coming to an end, and we're going to get back to normal soon. But things are behind right now in the court, so it may take a little bit longer to get your case heard than it would otherwise. A couple of years ago, a guy named Eugene came in to see me. Eugene was about 46 years old. He had been divorced about 7 years. He had a 10-year-old child and a 12-year-old child. Now, Eugene had been faithfully paying child support to the tune of about $600 a month for the last 7 years. The problem is that he had been paying it directly to his ex-wife, writing her a check every month, rarely missed a payment, and if he did, he made it up the next month. The problem was that the court order that ordered him to pay child support ordered him to pay through the state, in this case, Tennessee. And in Tennessee, you have to pay it through the child support receiving unit. He hadn't done that. He had paid it directly to her. Well, he got a letter from the state saying that he was over $40,000 in arrears, and he was going to have to pay $40,000. You want to know what happened? Well, tune in to part 2 to see what happened. Here's part 2 of the story. So, Eugene was going to have to pay $40,000 to his ex-wife, money that he had already paid because he didn't pay it properly. Turns out the lawyer that he had during his divorce had failed to do a wage assignment, and now he was going to be stuck with a $40,000 bill. He had all his canceled checks. There was no dispute that he had paid that money, but now he was going to have to repay it. The state was relentless. They didn't back down. Fortunately, John's ex-wife was, for lack of a better word, kind enough to accept the fact that he had already paid her that money. And we were able to convince the state of this, and we were able to enter a consent order that although John did have a small arrearage because there were some checks that he couldn't produce, he didn't have a $40,000 arrearage. So the judge signed off on the order, and he only ended up owing about $2,500. That was a good ending to an almost horror story.